The question of scientific replicability is no legal question. This statement may seem provocative at a time when some actors in scientific researchers or journals are pined for the publication of non-replicable results. In fact, that only means that scientific activity is not supported as such by the hard law, except to mention the main principles that define the missions of public research institutions and which are contained in France in the Code of Research and Education Code. What is remarkable is that principles of hard law are recalled in soft law texts, such as charters and codes of conduct, that makes the line between hard law and soft law not so clear. Several examples show this. The European Code of Conduct for Research Integrity of 2018 provides that researchers treat the subjects of their research, whether human, animal, cultural, biological, environmental, and physical, with respect and attention, and in accordance with legal and ethical provisions. The European Research Charter, General Principles and Basic Conditions for Researchers of 2005, makes it clear that researchers at all levels must be aware of national, sectoral, or institutional regulations governing training and/or work conditions. This includes intellectual property rights, regulations, and requirements and conditions of any sponsor or funder, regardless of the nature of their contract. Similarly, the Singapore Declaration of 2010 states that researchers must keep informed and comply with legislations and regulations. Thus, soft law contains hard law rules, either of which is directly recalls the principles or which it merely recalls as mandatory. This is why, while it is not be seen as a different source of law from others, ethics cannot be entirely regarded as a materially autonomous body of rules. In any case, it is important to point out, and this is what will structure my thinking, my presentation, that the issue of scientific replicability is indirectly supported by hard law, and in particular by intellectual property law. However, the question of replicability can also be addressed through the prism of the law of scientific integrity, the regulation of which, as I said, is ensured by soft law. Replicability and IP hard law. This hard law only takes an interest in the question of the replicability of results through the prism of patent law. Indeed, the patent is an economic and legal tool at the service of industry, allowing companies, often in partnership with public sector researchers, to have a monopoly of exploitation on products or services based on innovations. The industrial nature of an invention is an essential criterion of patent law because it is almost part of the definition of invention. An innovation that is not subject to industrial application is often a sign that it cannot be characterized as an invention because it would be too abstract. The question arose in particular as early as the 1980s about software or biotech inventions. In the case of biotech inventions, it is in particular the application itself that happens to be at the center of protection of the French patent law. The particular application of the biotech invention constitutes a condition of patentability, and the description of this application must even be described in the patent application, barely null and simple. The replicability of scientific results means that the invention has a sufficient technical character, thus participating in its definition, since it is known as that an invention is long defined as a technical solution to a technical problem. The invention has to be read by a person skilled in the art, and from this point of view, from this point of view, patent assessment are replicable. Patent law thus indirectly provides a regulatory function of scientific replicability for certain scientific results. That means those intended to serve an industrial exploitation. Scientific research and copyright law. While we can say that industrial property law provides a regulatory function of scientific research in that it guarantees the replicability of research results, the same cannot be said for copyright law. As David Ponty has shown in his work, the scientific signature has no function or even effect of guaranteeing the direct participation of the author in the production of the results themselves. The mention of contributors as required today in certain scientific fields ensures the visibility of contributors in the collection, preparation, cleaning, and curation of data. For example, to the question, what is an author? The recommendations of the International Committee of Medical Journal Editors for the conduct, reporting, editing, and publication of scholarly work in medical journals answer that these are those that cumulatively meet the following 4 conditions: substantial contributions to the design or methods of research or to the acquisition, analysis, preliminary drafting of the article or its critical revision involving a significant contribution to intellectual content, final approval of the version to be published, commitment to accountability for all aspects of research by ensuring that issues related to accuracy or integrity of any from the work are appropriately addressed and resolved. This visibility has 2 consequences on the responsibility of authors and contributors for their productions. One is active, the other is passive. The active responsibility allows the author to start a legal proceeding based on an infringement action based on proof of the originality of their work and authorship. On the contrary, the passive responsibility is to have to answer to the third parties of what authors said. Thus, the authorships or the contributorships also allows to know who assumes responsibility in the production and analysis of the results. While copyright certainly contributes to the regulation of scientific integrity, it does not guarantee, in my opinion, the replicability of results. This is a formal guarantee on the context rather than on the content of the scientific activity. And this formal guarantee is also very limited in all cases, now, like we saw before, in all cases of collaborative works that our copyright law does not properly catch. Now, replicability and integrity soft law. The open science movement is becoming a source of hard law since the European and national recommendations set out its main principles. One of the main principles of open science is that the results must be open as possible and closed as necessary. The terms of this principle are expressed today in the French Research Code, and open science is an interesting tool for regulating scientific research, and in particular for addressing the issue of replicability. I cannot answer the question of whether the rules of open science will be sufficient to solve the replicability crisis, but because we have seen through your interventions that these questions could be much more complex than it seems. But open science provisions can certainly be part of it. The openness of research data should raise the level of scientific integrity. At least that is the bet that is made by public research policies. At European level, the Code of Conduct of Research for Research Integrity provides in the section on good research practices that institutions and organizations maintain the appropriate infrastructure for the management and protection of data and research materials in all their forms, including qualitative and quantitative data and research and protocols, processes, other scientific objects, and associated metadata that are necessary for replicability, traceability, and accountability. A little further, the code states more specifically that researchers, institutions, and research organizations ensure adequate management and retention of all research data and materials, including those that have not been published, and ensure that their safe preservation for a reasonable period of time. The requirement to archive the data of the research allows thereby to ensure, in general, the archived material a superior quality, which is the sum of three discriminating criteria. Authenticity, that is the quality of an archival document, which is what it claims to be, and which has not been corrupted or altered. The integrity is preserved. 2, reliability, that is the quality of an archival document that can be given credence because it responds to completeness of form and control over the process of its creation. And 3rd, accuracy, that is the degree of which data are accurate, correct, truthful, and or adequate. Being able to verify a number of scientific results is in near real time and through the digital technologies that drive the open science process, may be an opportunity to highlight a greater number of cases of high scientific fraud or of scientific misconduct. At least the traceability of data can increase the reputational risk of research, like the papier activity has shown. Moreover, the question is whether scientific knowledge can be constructed from data whose origin is unknown, and therefore the meaning. There is a breakdown in data intelligibility, and if it would be decided that the genesis of the data must be known in order to be able to base a research, then the analysis should be placed in the field of scientific integrity. In the big data question, the difficulty is to know the origin, the genesis of data. Based only on the European Code of Conduct for Research Integrity, again, the requirement for knowledge of the context of intellectual, theoretical, and material data production is a matter of the obligation of reliability and research, which ensures the quality of research through the adopted methodology, the analysis and use of resources. The implementation of a rigorous scientific method requires that the use of the data is fair and honest. That means that the data is not falsified, truncated, or worse, fabricated. It should also be remembered that the failure to ensure reliable results is the most serious case of scientific misconduct. The major drawback of data science, science built on the analysis of massive data, is that it does not necessarily allow to know what data are produced or what data are reused by algorithm. Although this point is not mentioned in the text, knowledge of the origin and context of the data. It's not mentioned in the text, and we should perhaps suggest to write that the origin and context of the data should be set as a condition for the implementation of scientific integrity for data science. Knowledge of the context by the researcher himself, which seems obvious normally, and knowledge of context by the peers, the scientific community. The publication by the Lancet in the hydroxychloroquine case of a massive data analysis whose origin and homogeneity could not be demonstrated shows how crucial the issue is. The case also reveals that the collaborative form of the platform's operation allowed, wrongly in our view, to its owner and researcher to claim that he was exempt from liability and responsibility for the source, and therefore reliability of the data. The principle of traceability of data, allowed by its dissemination and at least by its accessible nature, helps to ensure that its genesis can be traced. By knowing the genesis of data, it offers the principle of data traceability, also allows the verification of the seriousness and honesty of the research protocol. Outside of it, the citizen or researchers would be condemned to either to systematically question the results obtained from an analysis based on the use of massive data, second-hand data, or to definitively place his trust in the people who collected, processed, and stored data. Thank you very much for your attention.